Good morning, everybody. It is my great pleasure to chair this session, the session which is organized together with the Association for Independence of Judiciary and World Peace. And we will discuss here extremely important issues. Now, based on my experience coming from a country where the judicial independence is under challenge, exactly this discussion plays a pivotal role. Many years ago, as I met first time Professor Szymon Chytryt, it was for me interesting experience that we are starting to discuss on independence of judiciary, but the subject was somehow abstract. It was not really something which I thought, yeah, it is a good exercise on drafting. It's a good exercise to discuss the role of judges, the structure of the courts. It is a place to collect experiences concerning the judiciary, and I have used a lot of them. But I have not expected how important this work will be in my life. That the question of the judicial independence will become not by my professional choice somehow, because my field of research was initially, at least, not linked to the independence of judiciary, but it is now, and it is thanks to Professor Chytryt. And of course, because, and this is the bright side of this problem, but the dark side, it is the political development. That this political development made exactly this project, which Professor Chytryt has started so many years ago, as one of the most important undertakings with the global dimension, but with extremely important practical application for countries, and in particular in such countries as my own country. But I'm extremely glad that that we can make this presentation for the European Law Institute, and I think there is a very important topic which has been already also addressed in our project on constitutional principles, the independence of judiciary. But I think it must be also further developed, and we have excellent speakers. I will very shortly, Professor Szymon Chytryt, Professor Giuseppe Ferrari, Lord Thomas, Professor Daniela Piana, and Professor Thorsten Ingo Schmidt. And I have to say, all of our panelists are also the members of the Association of the Independence of Judiciary. They have participated also in drafting of the rules and discussing the rules, so-called Scopus standards for judicial independence. And I hope for a very good discussion. I know that there is a very controversial subject, and we have heard it already also during our council meetings and a discussion on this topic. Therefore, I think it will be really extremely important session, and also for determining the further direction of the works of the European Law Institute. We are starting now with the presentation of Professor Szymon Chytryt from the Hebrew University. Thank you very much. Szymon, you have the floor.
Good morning. I would like to begin by expressing my deep gratitude to Professor Zoll and to Lord Thomas for making this session of a joint session with the ELI, the European Law Institute, possible. And I'm grateful for all the speakers who accepted our invitation. We are going to hold the 40th conference in Jerusalem in January of our association. This will mark 40 years of activities in pursuit of judicial independence, in the protection of democracy and the rule of law. My hope that after the Jerusalem conference, we will hold a conference in the United Emirates, where there is now a peace agreement between Israel and the United Emirates, or in one of the Gulf states, to market the idea of judicial independence in this part of the world. Today, in the limited time that we have, about 10 minutes, I would like to speak briefly about a very central issue of universality versus particularity in the context of the new and old democracies in Europe. This will be the first part of my presentation. Then I will discuss briefly the Mount Scopus standards. And finally, I would like to make a point or two about the possibilities of cooperation. Next. I will now use the presentation, the PowerPoint. As you see, the title is the Mount Scopus Standards and the New and Old Democracies Issues. Next. Next. There is a very important issue that has developed in Europe and the European jurisprudence in the issue of how we view institutions that have existed in all democracies, but are judged against the current context in new democracies. And next, when I'm thinking about how to deal with it next, we decided in Vienna, it was, in our conference Vienna, that we suggest that it is vital that supranational or international tribunals respect the fundamental principles of the legal systems of the member states, and to that end acknowledge the collegiality of the traditions of the courts of both municipal and extra-municipal courts. So next, this idea is that we represent a concept of constitutional pluralism. That is, we are not dominating totally the jurisdictions, the municipal jurisdictions, to accept every universal standards, but that it is possible for the national jurisdictions to apply it in the right adaptation of the special circumstances in each jurisdiction. Next, and we, in fact, we said, just for an example, the Lord Chancellor in England, until 2005, combined legislative, executive, and judicial functions, and we did not consider it a violation of judicial independence before 2005. And the same thing with the composition of the Conseil Constitutionnel in France and the top tribunal in Belgium. All these institutions are long established and are not suspected of being tailored to attack the independence of the judiciary or consciously to control judges. Next, and however, in new democracies like Hungary or Poland, when you discuss all the models of institutions that exist in other countries, you see that it is possible that they cannot pass the test of what we call the dominant improper consideration test. That means when you judge, when you judge the total context, you can see that it is not good faith and that it is in fact accompanying improper consideration, like in Volkov case in Ukraine. So the European Court of Human Rights did distinguish, let's say, between Ukraine next and Portugal in the same situation on the basis of judging the circumstances. So this is the first point I want to make. Second, I'd like to just check next and give you a brief presentation of the subjects that Mount Scopus standards deal with. Next, you see, in terms of what it happened, it started, in fact, in New Delhi in 1982, but later on, it was revised in Mount Scopus standards in Jerusalem, 2008, and was amended in a number of years in various conferences. The last one in London that we have amendments, even though we had also already another conference in London and another conference in Potsdam. The Mount Scopus standards are in fact dealing with the judicial independence, but also we have the Milan Global Code of Judicial Ethics that were adopted in 2015. Next. And here are the subjects, main subjects of the Mount Scopus standards. They are on the screen: significance of the concept, the relationship with other branches of government, and the terms of and the nature of judicial appointments, the rules on judicial removal and discipline, how the judiciary should interact with the media, standards of conduct, and how to secure impartiality and independence, and very important, the idea of internal independence of the judiciary, that is not only vis-a-vis the executive or the legislative, but also vis-a-vis the superior judges. And the last point I want to make regarding cooperation between ELI and the International Association of Judicial Independence, the JIWP. Next. Here are the points. One, to share the efforts to educate the general public on judicial independence, not only to the legal community, but to the general public. This is very important. Secondly, to work on a commentary on the general, on the standards of Mount Scopus, so that they will be available in a condensed and available form, and to hold specialized events on the subject of promoting judicial independence, like the one we're holding today, together with the ELI. Thank you.
Thank you very much, Shimon, for this brief but very important presentation, that we know exactly what the Mount Scopus standards are about and what is the main underlining idea and the balance which is immanent to this project. To our audience, we, of course, as usual, we have questions and answers questionnaire. So you may ask our panelists, and we will try to answer the questions within the frame of time. Now I have a pleasure to give the floor to Lord Thomas.
There is no one who is attending this webinar this morning who doesn't understand the importance of judicial independence, the rule of law, and the working of our constitutions. However, it is right to say that neither the rule of law nor judicial independence are well understood by the public, indeed by some members of the legal profession. And although from time to time, and it certainly happened this week in the UK, when the British government decided deliberately, as it accepts, to breach the rule of law in a most important respect in relation to a treaty it has recently signed, it is rare that these matters come to the head of the agenda. And I wanted to speak just about the independence of the judiciary, though it's closely allied to the rule of law and the functioning of the democracy. And the first point I wanted to make was the need to emphasize that close link. Of course, executive governments are generally and should be accountable to the legislature and to the public. But judicial intervention is from time to time critical. And this has happened in many countries at different times. For example, in England in the 17th century, just before the Civil War, to America in the mid-20th century in relation to public education. But I do think that the COVID-19 emergency has highlighted the importance of the executive being constrained and the role of the judiciary in this, and therefore the necessity for their independence. And so I think, first of all, it's very important to get over a proper understanding of the role of the judiciary and its independence in maintaining the balance of a constitution. That, and my second point is that we have got to be conscious of the dangers of attacks on the judiciary and attempts to curtail it. Getting judicial independence up the political agenda is not easy. Many politicians do not like judges. They do not want judges to have a proper role because they interfere with the way in which some politicians wish to conduct themselves. Fortunately, not the majority, but there are a significant number who do not. And so it's very, very important that we push up the legal and political agenda the important position of the independence of the judiciary. But judges too, and this is my third point, have an important role. The judicial independence is a privilege, and judges have got to do their part in maintaining it. And for example, they've got to be efficient in delivering timely justice. They've got to understand and be seen to be part of the ordinary life of people. And they've got to have political courage. And that doesn't mean political courage in standing up to a government all the time, but realizing when actually the more courageous thing is to do nothing. And so I think there's a very important role in getting the position of the judiciary within itself better understood. And then my fifth point is the need to get a better public understanding. Of course, this should happen in education, throughout education, and it's a pity that in many countries, the constitutional issues, the role of democracy, the rule of law, and the independence of the judiciary is not on the agenda. But this should be, but it's a long-term prospect. But I do think what the judges should do is, and we who are interested in this subject should do, is to make much more use of modern media. I've changed my mind in respect of broadcasting. I do think that broadcasting court proceedings is important, making use of modern media. And I also think that it's important that judges better understand the use of social media, which has come so much to dominate our thinking and the influence of the way in which people work. Now, why is all this relevant to the Scopus principles? Well, Shimon Sharit has set out the principles, the scope of the principles. And it seems to me that what are those points of which I've spoken fall squarely within it. But why do you need principles? There's so much about judicial independence. Very many learned books are written on the subject. But I think that the time is appropriate for us to look in a European context, particularly in the context of the very new world in which we live as a result of the COVID-19 pandemic, at strengthening and clarifying the rules so that judges know and everyone knows in very concrete principles, easily understandable, what should be done. And therefore it would be a great honor and privilege to work with Professor Street and the rest of the judicial independence and world peace movement to try and get this Europeanized in as short a time as possible. We must recall that what has happened in countries in Eastern Europe over the last 2 or 3 years could easily happen in other countries, and we must safeguard the role of the judiciary. And the only way to do that is by clear rules for everyone to understand and by making the public aware of the importance of judicial independence. Thank you.
Thank you very much, Lord Thomas, for this inspiring words and ideas and this direction, which I believe very much we have to go. Now, Professor Giuseppe Ferrari. Oh, Professor Ferrari, are you with us? Yes.
Yes. Thanks again for the invitation. It's always a pleasure to meet so many dear colleagues and friends. I tried to keep the promise that I made at Potsdam in our last meeting in January, that is to make a complete review of state constitutions in order to find formulas able, if they exist, to protect the judicial independence. Of course, there is no magic formula. We know that independence itself is one of the so-called essentially contested concepts, the definition of which changes according both to time and place. Also, there is a problem of language, which changes into a problem of method. Constitutions belong to different cycles and have been adopted in different periods and historical moments. Their style and language are not homogeneous, although it is true that techniques of interpretation are likely to converge over time, and dialogue between constitutional and Supreme Courts is increasing. Some authors believe that constitutional documents are quite stylized, at least in some parts, mainly, above all, in the parts concerning human rights and the judiciary, where a sort of mainstream thought has prevailed, and they lament the globally standardized notions that have emerged. Others, referring to the constitutions of the post-Soviet cycle in the 90s, spoke of constitutional Xeroxing. The so-called transnational legal order has also added some more homogeneity. However, bearing in mind these shortcomings and the need to verify the law in action, constitutional text can actually be a good provisional starting point to carry out research on judicial independence, though we have to know that strongly rhetorical or bombastic propositions are not necessarily symptoms of stability and resilience to politics. An initial overview of a good number of constitutions shows that regardless of when they were adopted and the style they have, there is nearly always an explicit provision in the constitutions concerning the independence of the judiciary, with reference to it as a power in at least 10 cases, an order, a body, or a mention of its separation from administration or from the executive power, for instance, in Austria and in Denmark. There are in several cases, I counted at least 25 cases where such provision is accompanied by another one concerning the independence of individual judges, which can be reinforced through the prohibition of all interference with the judge personally or with his work, or through norms imposing to evaluate the case in a correct mental attitude, without fear, without partiality, or more commonly by underlying the judges and prosecutors are subject only to the law or to the Constitution, or sometimes to both. The separation of powers as a principle is quite seldom invoked, but in a few cases, the relationship with the legislative and executive are expressly mentioned. The reinforcing note is often the prohibition of the creation of special or extraordinary courts or tribunals, sometimes mitigated by the mention of the possibility of the creation of specialized chambers inside the existing court structures. Very often there is a mention of the publicity of judicial proceedings as a provision safeguarding impartiality, but also protecting judges from external influences. From the viewpoint of independence, the position of public prosecutors is also relevant. In a very small number of cases, their career is merged with that of judges, such as in Italy, in Bulgaria, in Morocco, and in Egypt. And in that case, both are considered magistrates and their posts are interchangeable. In the great majority of the legal systems, however, there are strong differences with regard to recruitment, legal status, salary, and above all in terms of relationship with the ministerial authorities, with prosecutors having obviously a much closer link. In most countries, judicial independence is upheld and protected also by self-governing bodies, such as high or superior judicial councils. They are now overwhelmingly present, but for a few constitutional systems, such as Germany, Denmark, and the Czech Republic. There are, however, very different models of self-governing bodies. For instance, sometimes judges and prosecutors are included together, such as in Italy, Bulgaria, and in Turkey, or to the contrary, there is a complete separation of two organs, or the distinctions of two chambers inside one body, like in Romania, or the complete limitation to judges, like in Spain. Another important variable is the distinction between a composition which ranges from an exclusive presence of magistrates, like in Greece, to a 2/3 or 3/4 or 3/5, like in Spain, majority, or a simple majority of judges, like in Slovenia, and an equal balance with political members, like in Bulgaria and in Belgium. Less frequently, the majority belongs to political members, like in Slovakia and in Slovenia and in Portugal. Peculiarly, Kyrgyzstan has no less than 3 governing bodies: the Congress of Judges on top of the pyramid, a Council of Judges, a kind of executive that works in the interval between a Congress and another one, and an Assembly, detailed regulations being delegated to a statute. In some cases, the composition and the functions are all left to a statute. There is a whole spectrum of solutions in functional terms as well, from the complete control of the entire career of judges, like in Portugal and in Spain, and also prosecutors, like in Romania or in Slovakia, to a mere role of advice to presidents and or to governments, so that there is no single pattern of organization of these self-governing bodies. Another problem is the kind of legal source to which the detailed definition of the regulation of the self-governing body is delegated. Very frequently, the legal source contemplated is an ordinary statute, but in several cases, there are organic laws, such as in France, in Spain, and many other countries, or cardinal laws, as in Hungary, or qualified laws, or constitutional laws. Another critical theme that is crucial for the efficiency of a judicial system, but may prove to be a Trojan horse in the case of democratic retrogression, is accountability. In this field, some constitutions excluded at all any form of judge responsibility, like in Bulgaria and Portugal, or with exception for willful crimes or for flagrant crimes. Other constitutions simply declare judges responsible without further details, like in Spain. Independence and accountability, of course, go hand in hand. However, total exclusion of responsibility does not always amount to concrete full independence. There are, of course, several types of constitutional provisions on the independence of single judges, such as prohibition for judges to be members of political parties or movements, and provisions concerning the incompatibility of judicial duties with other offices or professions, with the exclusion of scientific research, administration of one's property, or election or nomination to the High Judiciary Council when existing. the text of the Constitution is not in itself a reliable instrument in measuring judicial independence, indeed resorting to a used and abused expression in order to obtain useful results, one has to go from text to context. Living constitutions have to be kept into account more than text. Careful analysis of the legislative implementation of the constitutional provision is absolutely required for a more complete area and for a more complete research in this area. And also one has to focus on administrative acts and even more on settled practices that may have taken shape over the years as a result of loophole or lacunae in the laws or other statutory instruments. Thank you for the patience. I'm a bit late on the schedule.
Thank you very much, Giuseppe, for this important reference to the Constitution and to relation between the reality of the judicial independence and constitutional text. Now we are coming to Professor Thorsten Ingo-Schmidt from University of Potsdam. He will speak about the Council of Judiciary, and it's also a field which is extremely important. Our experience is now that the Council of Judiciary, who was a shield for judicial independence, has changed in Poland completely. Its function has been also suspended in the network of judiciary councils. Therefore, it will be extremely interesting, and I'm waiting for your presentation. Professor Schmidt.
Good morning from Potsdam, and thank you very much, especially to Frederick and Shimon for the possibility to hold this speech. I will talk to you about the institution of the Council of the Judiciary and its impact on judicial independence. Judicial independence is based on independent judges. But how does a judge come into office? The problem of appointing judges is fundamental for any independent judicial power, as the recent developments in Poland demonstrate. Whoever drafts a constitution has to deal with this problem and has to find a solution between the aim of judicial independence on the one hand and the necessary democratic legitimation of the judges on the other hand. In the problem of appointing judges, the constitutional principles of the rule of law and of democracy collide. Councils of the judiciary may pose a solution to this problem. In the following text, I will deal with the typical structures to choose judges. I will look at the reasons for and against the participation of different entities in the process of electing judges, and I will finally regard further potential competences of councils of the judiciary. At the end, I will sum up the main results. To the typical structures to choose judges. If we look at the problem of choosing judges from the point of view of the pouvoir constituant, i.e. from someone who has to draft a constitution, there are at least 5 potential ways to nominate judges. First of all, one may provide an important role for the legislative power. The parliament or parliamentary committee may be held responsible for electing judges. Secondly, one may stipulate a special role of the executive, especially of the Minister of Justice. Thirdly, one may attribute the recruitment of judges to the judiciary itself, particularly to the justices of the Constitutional Court. Moreover, fourthly, one may include lawyers and professors of law in the process of decision-making. Finally, one may combine the 4 models mentioned so far. Now, let's have a look at the different entities in detail and the reasons for and against their participation in the nomination process. To the legislative power. If we consider the legislative power, the main aspect for its important role in electing judges is its own direct democratic legitimation. In Parliament, different political views meet, collide, have to compromise and find solutions. These varying political ideas may be reflected in the judiciary if the deputies have an important say in choosing judges. On the contrary, deputies tend to prefer the political orientation of judges to their judicial competence, and they don't guarantee an adequate standard of nominated judges. If the power to choose judges is laid in the hands of the executive instead, especially into the responsibility of the Minister of Justice and his or her department, the academic requirements show a tendency to be higher. Moreover, the executive has a special knowledge of the administrative aspects of the judicial sector and has to plan, to defend, and to carry out the budget of the judiciary. On the other hand, the executive may be looking for judges who are soft on executive decisions. If one accepts the notion that the judiciary shall control the executive, this task can't be performed adequately if the executive alone can exert such a great influence on the judiciary. So, one might come to the conclusion the judiciary itself should appoint new judges, as judges know best what a good judge should be like. If someone drafting a constitution follows this way of choosing judges, the political influence on the appointment process can be reduced. However, this nomination procedure leads to a self-complementation of the judiciary and may finally result in a kind of judicial aristocracy supplementing itself. The democratic legitimation of judges is thereby severely reduced. If we look at other groups of experts in law, such as lawyers or university professors of law, they may have a different view of law and can enrich the process of nomination by their special perspective. However, they are not democratically legitimated in the same way as the other groups discussed, and they don't carry the same amount of political responsibility. As a consequence, it can be observed that there's no ideal way for recruiting judges. Every entity named above has its special advantages and disadvantages. Therefore, the different powers should be combined in the institution of a council of the judiciary. Such a council should be composed of parliamentary deputies, of the Minister of Justice, and of representatives of the judiciary itself. It may be supplemented by one or two lawyers, as well as some university professors of law. In my opinion, the deputies should claim half of the seats in this council due to their eminent democratic legitimation. The judges approximately 1/3, and the remaining seats could go to the Minister of Justice, who may also preside the council, and to the lawyers and university professors. Combining the different institutions in this way, the requirements of democratic legitimation and of judicial competence can both be met, and the problems arising from appointing judges only by the legislative or the executive or by the judiciary itself are avoided. A council of the judiciary composed in this way should primarily be responsible for appointing and promoting judges. In disciplinary matters, it could also be held competent to sanction misbehavior of judges. In those cases, it could become the authority responsible for transferring, demoting, and in extreme cases, even dismissing judges who have broken a panel law. Apart from these competences in personal matters, the Council of the Judiciary could also comment on the general organization and the way of procedure of the judiciary, and even formulate a first draft of the budget of the judiciary. Summing up, it may be said that the appointment of judges leads to a conflict between the principles of the rule of law and of democracy. A Council of the Judiciary, composed of deputies, the Minister of Justice, and of judges themselves may help to resolve this dilemma. Such a council could be granted procedural and fiscal competences as well. Thank you very much.
Thank you very much, Professor Schmidt, for this probably very important, crucial presentation, in the sense that this is exactly one of the most important problems: how to envisage what is the source of the judicial power in the way of appointment, and also the promoting of judges, which is an important problem in the system, which are structured as continental system in some kind of bureaucratic way. Thank you very much for this. And now we are coming to our last, but also extremely important presentation, as we have seen also yesterday, talking about the artificial intelligence and the public administration. And now we have exactly the same challenge, but even with more constitutional power, the question of the impact of the development in the field of artificial intelligence and the independence of judiciary. Professor Piana, thank you for being with us.
Thank you. Good morning, everyone. And let me start by expressing my warmest gratitude for having me on this panel, and to give me the opportunity to share with you some very concrete proposals to integrate the standards on judicial independence, having in mind the digital transformation and the encounter between artificial intelligence and courts. Just before we start to share the presentation, which is then shared with all of us, let me say that the purpose of my talk is to try to see how the guarantees of judicial independence, as we have developed over the decades in terms of standards, may remain the universal reference point, even though in the specific context where artificial intelligence is integrated into both legal reasoning, judicial decision-making, and court management, there might be the need to have supplementary guarantees and protection to ensure that judges and courts are not under attack. Let me be very frank with you. I think that there are countries in which the danger brought about artificial intelligence for the independence of judges and courts is more serious because of the lack of trust to the judiciary or the judicial procedure. And in this respect, you may see that easily artificial intelligence is mentioned as a medication to the disease, the malaise of court systems, and especially the efficiency of the judiciary. So I think that this is something we must keep in mind. So let's share the presentation now. Just a couple of words. When we speak about artificial intelligence encountering and meeting the justice systems, what we have in mind, what does it mean? Well, in fact, this is a reality already, and it touches upon basically three main dimensions. First of all, the big data analysis, by means of which contents produced with automated tools may be provided to lawyers and judges. Secondly, this data may be combined with the social data, social statistics, they allow to make a profiling of social behaviors, which may be also used as a prognosis to assess the probability that some behaviors may be put in place. Then you have the application of artificial intelligence tools in the court management to optimize the allocation of resources. And finally, in some context, we heard already about the possibility to replace the judge with a robot. This is not an exaggeration. I mean, there is, again, this is sort of a dream to have the max impartiality, the max objectivity and efficiency all together combined. And this is the danger, the promise of a robot adjudicating disputes, but most of all, mostly important, defending rights. This is the danger, the trap in which we should not fall. So now, a couple of ideas how to reframe judicial independence and maybe to integrate the standards and the policies that we have in mind when we want to ensure the guarantees of judicial independence put in place within the domestic settings. And I thought to use the very well-known distinction between de jure and de facto judicial independence, because this recalls also what has been said. The constitutional text, the formal rule is not enough, is necessary but not sufficient. So I think that first of all, we must have a judicial review and the constitutional control of the algorithms that are used in the context of the justice system. And this is extremely important. And this relates immediately to the right to access the algorithm, even though I know that this is very problematic. I do not have the time to enter into this puzzle, but I think that in some way we need to entrench this right. And second point on the jure side, the algorithms and the artificial intelligence tools must be subjected to the same dialectic and confrontation that you have in the trial. So they must be used as expertise, not replacement, because the calculus is not the adjudication of a judge. It's a completely different thing. On the side of de facto judicial independence, I think that the countries, this is at the domestic level at least, even though why not at the European level? I think that is important because judges cannot become specialized in artificial intelligence, of course, but they must be aware and they must have the lead in the final end about, you know, the instrument. The artificial intelligence is just a tool among others. And so in this way, a committee where judges, specialists in information science and data science, and the bar must be convened regularly to discuss the way these tools are used, but above all are built. And this is my last point, which goes to the last slide. The artificial intelligence, let's say, most dangerous dimension is not in the use, is in the way the tool is built. So when someone tells us that this is something that you can solve by means of the ethics by design, the fairness by design, this is not true, because in fact what matters is which type of data you use to build the algorithms and in which way you operationalize the data where the machine learning process is running. So it is important that this part, the design of the artificial intelligence tools that are applied within the justice systems, is kept in the hands of the public sector. Of course, market interests are very strong, very much indeed, and we should not be blind. But in fact, the pillar and the core business of the governance of these tools must be in the public. And I think that in this respect, the Judicial Council has a very important role to play here, is a no frontier, but this is absolutely the way you need to start to have technology and digital technology, which are the basis of artificial intelligence, within the public sector in order to guarantee that you do not have an attack to judicial independence also from this side. Thank you very much for your attention, and I would be absolutely glad to take questions if there are.
Thank you very much. Thank you very much for these fabulous presentations. We have now about 10 minutes for questions and answers. Please use the questions and answer questionnaire for asking our panelists. We have already questions, the first from Professor Ahrens. Independence cannot be regarded only as an issue of being threatened by the executive. Administrative courts in Germany shift the balance of power when extending their power by replacing executive prognosis on the risk of corona pandemic without better access to facts. I think we are here starting with the crucial issue of the balance between the executive and judicial power in the related to pandemic situation, but the question has much broader dimension. Szymon, I will ask you, and then Professor Thorsten Schmidt for a very short comment on it. Szymon, you are muted.
Yes, I think the question is very important, not only for administrative courts in Germany, but all over, when the judiciary is requested to review executive functions, and also when it is required to review statutes, constitutionality of legislation. The answer, in my opinion, should be that whenever the decision of the judiciary substantially interferes with the balance of powers between the branches of government, then the judiciary should be careful in intervening in the question. When it is a substantial interference, depends on the current and the climate of each jurisdiction. So in my opinion, this is the test that should be applied in order to make sure that there is a fine-tuning of the boundaries between the territory of the judicial branch and the functions of the legislative or the executive branch.
Professor Schmidt, you are muted.
Okay, that's a very good question. As far as I see it, I don't think that the independence is threatened by the administrative courts. If the executive and the administrative courts have to deal with scientific results, then there's no special privilege of the executive to interpret these results. And it's not a kind of core area of the executive to deal with these results and to base their decisions on them. As far as I see it, administrative courts are at least as competent as the executive to interpret these results. Thank you.
Thank you very much for your answer. And now we have the question of Clara Fahrleitner for Lord Thomas. You mentioned the urgency of making the public aware of the importance of the independence of judiciary. How would such awareness be implemented? And in your opinion, would it realistically be the state's obligation as a political entity or the legal system's obligation to do so? Or would it otherwise be more of a social phenomenon, well, informing the public on social media, etc.? Okay.
My own personal experience is that government's contribution is very important. In the UK, there's a statutory obligation upon them to uphold judicial independence. But I frankly do not trust politicians in every respect. And they are sometimes not interested in upholding the independence of the judiciary, as I found when I was personally attacked. And therefore, it's very important, although the majority of politicians will do so, some won't. And so the judiciary must be prepared, together with academics and others interested, particularly the more responsible media, in doing what they can to educate the public. And the judges themselves should be prepared, as I hope I indicated, to be prepared to engage in social media, not without some very clear guidance or under the supervision of something like a council for the judiciary, but the judges have to look after themselves.
Thank you, John. Now the question of the Judge of Supreme Court of Teresa Bierska-Sobkowicz. I would like to thank all panelists for excellent presentation. The general conclusion seems to be that there is no one ideal pattern of rules obtaining the independence of judges. So the question arises, what measures can be taken to effectively prevent destroying judicial independence? The constitutional rules are more or less dealing with the motion of judicial independence everywhere. The problem lies in practice. What can you say about the role of legal practitioners who are in fact destroy democracy? I mean, those who write drafts of law for politicians, academics who do not react because of fear of their career when judicial independence is in danger. Is there a possibility to disseminate the Scopus rules to the wider legal community? Professor Ferrar.
Extending the rules to a wider legal community, it's not easy. I remember that before our Mount Scopus declaration, there have been several other between private and public declarations, such as I recall the International Bar Association minimum standards in 1982, the Montreal Declaration on the Independence of Justice in 1983, and the Universal Charter of Judges in 1999. We still have to do something to promote the research for the reaching of a general standard notion, which might achieve a final general recognition. It's not easy. I guess something can be done in a relationship with the bar, activating some promotion with national bar associations, because you know, it's not only a problem of persuading politicians. I agree with Lord Thomas that it's very difficult to get a full persuasion of the political class, above all in some recently democratic or as many people now say, illiberal democracies, where it's hard to persuade the political class. So that probably the bar is to be persuaded that having an efficient and independent judiciary is important for all. I noticed a question on the link between the market economy and the independence of the judiciary. I do believe that a serious independence is very important for the market, because in a globalized world, investors tend to move to countries or places where they can rely on an efficient and independent judiciary.
Thank you very much. We have still time. Professor Piana wanted also to comment on the role of the bar.
Yes, thank you. Very, very quickly. I think that the bar, the engagement of the bar in all policies ensuring judicial independence is just a necessary and vital condition to have these guarantees in fact put in place. And this applies also to the domain of the artificial intelligence tools, because the data that are used are coming also from the legal documents, and it is absolutely important that the synergy between the judiciary and the bar is in place. In the Scopus, there is a chapter on the culture of judicial independence, and when we say culture, it means the bar as well.
Thank you very much. We have, I got from the Secretariat information, we have still 10 minutes because there is a large number of questions. We don't want to lose them. There's a question of Professor Szostak, also to Professor Piana, I guess. As early as today, judges are already deciding using algorithmic legal systems, legal information systems. The use of AI is the next step. Algorithms may be threatened by external actions. This may affect data made available to the judges. Would it not be appropriate for this algorithm to be controlled? And who would do it? Is this not a threat to the independence of the judge? Professor Piana.
Well, thank you very much for this question. I think that it touches a very important point, maybe the most important. I mean, we do not have the control on the data that are circulating on the net. That's of course, as we know. But what we can do is to certify the algorithms and to validate those tools that are used in the courts and in the justice system. I think that we need to have a regulation and a body to validate these tools. And this goes through a process of assessment, which must cover all the way along from the data selection to the design, the machine learning process, and the application of the tools. That's the reason I'm saying the public must handle this process entirely.
Thank you very much. Now we have a question of David Herzl. You have quite properly focused the discussion on judicial independence and constitutional concerns. Do you also think that independent judiciary helps underpin a successful market economy? Szymon, maybe you take the floor. But you have to unmute yourself. Szymon, you are muted.
As already Professor Giuseppe Ferrari said, any investor or any trader would like to be ensured and satisfied that when there is a dispute, either between a business partner or a citizen or a government agency, that he will get a fair trial. And fair trial depends on integrity and judicial independence. And therefore, anyone who wants to do business with a country would like to check if there is judicial independence. Not only that, any country that there is a decision, either by arbitration institution or by a court, and the judgment has to be implemented, enforced in another jurisdiction, according to case law in many countries, that award of the arbitration or the judgment of the court will be enforced only if it passes the test of integrity and judicial independence. So therefore, we consider judicial independence essential for market economy, essential for international trade, in addition to being essential for liberty and essential for the rule of law.
Thank you very much. And now the last question we can take to Lord Thomas. Current events by Britta Kinast. Current events underline the importance of lawyers for the independence of the judiciary. Could you comment on this?
Independent lawyers and all lawyers have a central role. An independent judiciary cannot exist without independent lawyers. And that's why organizations such as the CCBE in Europe, the national bar associations, and bodies such as the International Bar Association are so important, because at any gathering you will find that the first and easiest line of attack is to attack the lawyer, try and stop them going, try and make it unattractive, and in certain dictatorships obviously kidnap them or punish them or torture them. And so they are integral to our system, and a strong independent legal profession or professions are central to the independence of the judiciary. I do not think one can emphasize that too much.
Thank you very much. Or maybe I take the last question, which we have here. We have 2 minutes. I think it's important. Ivana Friedhoff, long term, the teaching of the importance of the rule of law and the independence of the judiciary in schools must surely be a priority. All the other suggestions discussed would then be falling on fertile soil. I think, Shimon, because it is your, in certain sense, your panel in this way, but of course, but it's the Scopus, it's the organization which you have established. May you have this last word on the importance of the teaching children on, or teaching in schools on independence.
As we said before, we have to extend our efforts beyond the legal community. We have to deal with this very challenging task of education of the public, and therefore education, the leadership, the political and public leadership, and what we call the civil society organizations. And this way can be done, or this can be done by either going to the schools, by public media, discussions in the various forms, and by the relevant publication in simple language, explaining the idea, explaining its vitality to the everyday life, the quality of life of the ordinary citizen, if there is independence, and if there is not, what interference that can be made against him if there is not a judicial independence. We can see it in countries that are authoritarian or countries that do not respect the rule of law. And I take this opportunity to thank everyone, including those who took part by listening and putting questions.
Thank you very much. Thank you very much to everybody, to all panelists for this presentations. And I think also the number of questions has shown how important the issue is. Thank you very much for all participants in this webinar. And I think this webinar was kind of part of being of participating in the culture of judicial independence. And I think for the ELI, it should be one of the most important questions and matters to be dealt with in this difficult time. Thank you very much. Thank you very much to all of you for agreeing, being with us. Thank you for all, for ELI Secretariat for perfect organization of this panel, or helping and supporting us all the time. Thank you. See you.
Thank you very much.